Good morning to everyone who is joining us from in or around the court, and also to those joining us from the Republic of Kenya via the internet or otherwise. I will now turn to the merits of Case 1, the prosecutor versus William Samuel Ruto, Henry Kiprono Kosgey, and Joshua Arap Sang. It concerns crimes committed in Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills from on or about 30 December 2007 until the end of January 2008. I would like to underline the following. As mentioned at the start, the prosecutor charged Mr. Ruto, Mr. Kosgey, and Mr. Sang for crimes against humanity of murder, deportation or forcible transfer, and persecution. Mr. Ruto and Mr. Kosgey were charged as indirect co-perpetrators, while Mr. Sang was charged as having contributed to the said crimes against humanity. I will first summarize the filings of the Chamber on the crimes and then the findings as to the criminal responsibility. With respect to the crimes charged and based on the evidence placed before it, the Chamber found that the prosecutor has established substantial grounds to believe that the crimes against humanity of murder, deportation, or forcible transfer and persecution were committed. These crimes resulted in the death of hundreds and the displacement of thousands of civilians from Turbo Town, the Greater Eldoret area, Kapsabet Town, and Nandi Hills. The Chamber also found that these crimes were committed as part of an attack directed against particular groups, namely Kikuyu, Kamba, and Kisii, due to their perceived political affiliation to the Party of National Unity. As to the criminal responsibility of Mr. Ruto and Mr. Sang, the Chamber found, on the basis of the evidence presented, that they are responsible for the charges levied against them. In particular, Pre-Trial Chamber 2 confirmed the charges against Mr. Ruto as an indirect co-perpetrator with others, while it found that Mr. Sang contributed to the commission of said crimes against humanity to the extent specified in the written decisions. However, in relation to Mr. Kosgey, the Chamber found that the prosecutor's evidence failed to satisfy the evidentiary threshold required. The Chamber was not persuaded by the evidence presented by the prosecutor of Mr. Kosgey's alleged role within the organization. In particular, the prosecutor relied on one anonymous witness insufficiently corroborated. Moreover, the Chamber determined that Mr. Kosgey suffered prejudice due to the reduction of certain dates related to a number of meetings that he allegedly attended, which proved to be essential for his defense and equally essential for the findings of the Chamber on his criminal responsibility. In light of these facts and the entire body of evidence relating to Mr. Kosgey's criminal responsibility, the Chamber declined to confirm the charges against Mr. Kosgey. Turning now to case 2, the prosecutor versus Francis Muthaura, Uhuru Kenyatta, and Mohamed Hussein Ali. As mentioned earlier, the prosecutor charged Mr. Muthaura, Mr. Kenyatta, and Mr. Ali with crimes against humanity of murder, deportation or forcible transfer, rape and other forms of sexual violence, other inhumane acts, and persecution. Mr. Muthaura and Mr. Kenyatta were charged as indirect co-perpetrators, while Mr. Ali was charged as having contributed to the said alleged crimes against humanity. As to the crimes, the Chamber found, on the basis of a thorough review of the evidence individually and collectively, substantial grounds to believe that between 24th and 28th January 2008, there was an attack against the civilian residents of Nakuru and Naivasha, perceived as supporters of the Orange Democratic Movement, in particular those belonging to the Luo, Luya, and Kalenjin ethnic groups. The Chamber also found that the attack resulted in a large number of killings, displacement of thousands of people, rape, severe physical injuries, and mental suffering. Thus, the evidence established substantial grounds to believe that the crimes of murder, deportation or forcible transfer, rape, other inhumane acts, and persecution were committed. With respect to the criminal responsibility of Mr. Muthaura and Mr. Kenyatta, the Chamber was satisfied that the evidence also established substantial grounds to believe that they are criminally responsible for the alleged crimes as indirect co-perpetrators. However, in relation to Mr. Ali, the Chamber found that the evidence presented does not provide substantial grounds to believe that the Kenya police participated in the attack in or around Nakuru and Naivasha, since Mr. Ali was charged with contributing to the crimes through the Kenya police. The Chamber declined to confirm the charges against him. The Chamber will now outline the impact of its decisions on, first, those against whom the charges have been confirmed. Second, on those against whom the charges have not been confirmed, namely Mr. Kosgey and Mr. Ali, as well as on the victims. As a result of the decisions issued today, Mr. Ruto, Mr. Sang, Mr. Muthaura, and Mr. Kenyatta are committed to trial. They will be tried before a different chamber for the charges confirmed. To this end, one or more trial chambers will be established by the Presidency of the International Criminal Court. In this regard, the Chamber wishes to highlight that victims who are already represented before this chamber may participate in the trial. Other victims will have the right and opportunity to apply to participate during the trial stage. Victims will have also the right to request reparations should the accused persons be found guilty. The Chamber wishes to be unequivocal and state that Mr. Ruto, Mr. Sang, Mr. Muthaura, and Mr. Kenyatta are merely accused before this court. The Chamber would like to emphasize, for the purposes of clarity, that the presumption of innocence remains fully intact. At trial, the prosecutor will have the burden of proving the guilt of the accused beyond a reasonable doubt, as required by Article 66 of the Rome Statute. Furthermore, the decisions issued today by this chamber do not affect the liberty of the accused, which remains undisturbed. This, however, absolutely depends on the accused's adherence to the conditions contained in the summonses to appear, which continue to remain in full force. At this point, the Chamber recalls its previous warning to the suspects that their continued liberty is subject to their non-engagement in incitements of violence or hate speech. As to Mr. Kosgey and Mr. Ali, the Chamber wishes to clarify that they are no longer suspects before the International Criminal Court. However, the Chamber recalls Article 61(8) of the Rome Statute, according to which prosecutor may present additional evidence requesting confirmation of charges against Mr. Kosgey and Mr. Ali. We have now concluded the summary of the Chamber's decisions in Case 1 and Case 2. At this juncture, the Chamber would like to express a few sentiments. Today, and indeed throughout the proceedings in these cases, we have appeared in our official capacities as judges of the International Criminal Court, offices which task us with the sole purpose of achieving justice, justice for all, for victims, but equally justice for those who appeared before the court. This is not rhetoric, but is a tangible goal we all genuinely strive for. In reaching our decisions, we have reviewed all the evidence individually and collectively, regardless of its source, firmly guided by the provisions of the court's statutory documents. In the fulfillment of our judicial mandate, we have looked through impartial and independent lenses in order to ascertain whether the requisite threshold in Article 61 of the Rome Statute for confirmation of the charges has been reached. It is our utmost desire that the decisions issued by this chamber today bring peace to the people of the Republic of Kenya and prevent any sort of hostility. The decisions are the result of intensive and committed judicial work of the chamber, conducted impartially, independently, and conscientiously in the interests and in the service of justice. That concludes Pre-Trial Chamber's 2's appearance this morning. Before we leave the courtroom, on behalf of the Chamber, I would like to thank everyone who has been following this public appearance, and especially to thank the people of the Republic of Kenya.
All rise. Veuillez vous lever.